Hello and welcome to topic 11, lecture 1, our second to last topic for this semester. And this week we're going to be learning about evidence and investigation, in particular the Fourth and Fifth Amendment. So for this week you're supposed to be reading chapter 11, but before chapter 11 there are some pages and they're listed in your course calendar. They're also listed in the Canvas site. There are pages before chapter 11 that you're supposed to be reading because for the next 2 weeks, we're shifting gears and we're going to be focusing on the rights of the criminally accused. And so this lecture is going to focus on what those rights of the criminally accused are, sort of an overview of what you're going to be learning in the next 2 weeks, and how those rights that are in the Bill of Rights overlap with the criminal justice process. Then in this lecture, we're going to take a look at the Fourth Amendment and the two clauses that are in the Fourth Amendment. So let's get started. So as you probably already know, a substantial portion of the Bill of Rights deals with the rights of the criminally accused. Of the 10 amendments in the Bill of Rights, 4 of those are dedicated to dealing with the issue of the rights that are afforded to those who are accused of crimes or are being investigated for potential criminal activity. So let's take a look, an overview of the different amendments and what they relate to. And then on the next slide, we're going to look at how these amendments overlap with the criminal justice process. I know there are a couple of the students in this class who are also in my criminal justice class, so there's going to be some overlap, at least in this first couple of slides here. So the Fourth Amendment deals with search and seizure, and in this lecture and the next lecture, we're going to be focusing specifically on what constitutes a search. The Fourth Amendment also deals with warrants and what needs to be in place for law enforcement to get a warrant to either search somebody or to arrest somebody. The Fifth Amendment deals with the general idea of due process. So does the 14th Amendment. Because it says that your life, liberty, or property cannot be taken from you without due process of law. We're going to talk about what that means in a second. It also deals with the right to a grand jury, double jeopardy, and the right to remain silent. The Sixth Amendment, we're going to be looking at the Sixth and the Eighth Amendment next for the final topic of the semester, topic 12. For this topic, we're looking at the Fourth Amendment and the Fifth Amendment. Next week, we'll be taking a look at the Sixth Amendment, which includes trial rights and assistance to counsel. And we'll also be taking a look at the Eighth Amendment that deals with punishments. The Eighth Amendment says that there shall be no excessive bail or fines and also no cruel and unusual punishment. And so for those in my criminal justice class, we just got done talking about bails, and so the Eighth Amendment plays a role there. But in this class, we're going to be taking a look at cruel and unusual punishment. Now, why is nearly 40% of the Bill of Rights dedicated to the rights of the criminally accused? Well, the framers knew the excessive power of the state in criminal matters, and they knew that those excessive powers, as it relates to fighting crime and apprehending people for crime and trying to find people, investigating people for potential crimes and also punishing people. They knew that the power of the state is probably at its mightiest when it comes to apprehending criminals. And so, always when it comes to some of the civil liberties we've talked about during the course of the semester, the state has a lot of power. The individual doesn't have a lot of power. So the Bill of Rights is designed to curtail the general power of the government. But the state is even mightier and the individual is even weaker when that individual is accused of a crime. Government places a lot of a premium on fighting crime and holding those who break criminal law accountable. And that's in a little bit we're going to be talking about why that's important for living in a democratic society. But when it comes to those who are accused of crimes, it's easy for society to look down on those people, to assume that if you're being investigated and arrested for a crime that you're probably guilty, right? And so while we're maybe less uncomfortable or less comfortable with curtailing the rights of somebody practicing their religion or exercising their freedom of speech, unless they're a communist, right? I mean, we sort of see this played out in many ways. Exercising your right to bear arms. in those instances, it's easier to protect individual rights because you're like, they're not breaking the law. They're doing something. They're exercising this sort of liberty that's essential to a democracy, freedom of speech, the press, exercising your religion. But for those who are accused of crimes, it's easy to say, well, they don't, they must be guilty. So really, do they need all this robust protection? But our framers knew that was precisely at the moment when we needed to make sure that people who are accused of crimes were not taken advantage of by the state, because it's easy for criminally accused to be taken advantage of. So that's why they dedicate a lot of the Bill of Rights to the rights of the criminally accused. So for those of you taking my criminal justice class, you know that we spent a lot of this semester talking about the steps in the process for the criminal justice system. For those of you not in that class, some of this information is obviously going to be new to you. And so your textbook has a really nice sort of overview in Figure 3, 1, and this is in that material prior to Chapter 11, that basically summarizes some of the steps in the criminal justice process. And then, so on the one hand, it has the stages, and on the other hand, it has the governing amendments. So why are you learning about this? Well, you're learning about this because as you're reading these cases this week and next week, you'll be coming across like a reference to the criminal procedures, to the steps in the criminal justice process. And so you don't need to be experts on it. That's not what this class is about. But knowing what these steps are is going to make it easier for you to understand those cases. And also for this class, how the amendments in the Bill of Rights, those protecting the rights of the criminally accused, how those intersect with those stages. So taking a look at this, that crimes happen, and then a lot of them are never reported to the cops. Okay, so like for every 2 crimes that are committed, serious crimes that are committed, 1 doesn't even get reported. Only about 50% of crimes actually get reported to the cops for a variety of reasons. But once a crime is reported to the police or the cops witness a crime taking place, at that point, that law enforcement will engage in an investigation. So a lot of the cases that you're going to be reading this semester are about the process of the cops investigating people who they think might have engaged in criminal activity. And so, you read a case about cops having many hunches about, in several of the cases about people either growing marijuana in their house or transporting marijuana. I'm always wondering, like, what's the Supreme Court going to do when marijuana is nationalized, legalized nationally, right? No more cases will come, right? But so many cases have to do with hunches that cops have that people are drug trafficking. And so that they're trying to you get evidence through their investigation to get a warrant, right? And so the first thing the cops do is they begin investigating a crime, right? And both the Fourth and the Fifth Amendment are triggered as a part of that investigation. The Fourth Amendment has to do with what is considered a reasonable search and what needs to be in place for you to get a warrant to search somebody. The Fifth Amendment matters because part of the investigation is talking to people that the cops think might be involved in a criminal activity. But people have the right to remain silent in the Fifth Amendment, and that they are told that as a part of their Miranda rights from the landmark case Miranda v. Arizona, that they have the right to remain silent, and so that is a big part of the restraints that are placed on government as they are involved in investigation. After if there is enough evidence to search your home and there's probable cause that you have committed a crime, then an arrest warrant will be issued. And an arrest warrant, once you are arrested, that Sixth Amendment gets triggered, because at the point of arrest, you have the right to counsel. And so, as you know, with the Miranda rights, you have the right to remain silent. And if you can't afford an attorney, one will be appointed to you. That comes from the Sixth Amendment. So even before you go to trial, well before you go to trial, you have your Sixth Amendment rights. It starts with arrest. You're going to be booked after arrest. You'll be brought down to the criminal station, the police station. You'll be booked, fingerprinted, photographs will be taken, and bail may be set at that point as well. and you have the right to counsel at that point of booking. Once you have been sort of the decision is made that the prosecutors are actually going to charge you with the crime, you can be arrested and booked but never charged, right? But once prosecutors say that there's actually enough evidence to charge somebody with the crime, then they'll move forward on that. And that's the next step here. There's pretrial hearings that place a check on the power of the prosecutor as they're determining whether to charge somebody with the crime. And that triggers the Fifth Amendment right to a grand jury. That you also are brought into the courtroom and told what your charges are. Again, you have the right to counsel at all of those points. And after you are told what the charges are, you're asked to enter a plea. And if you plead not guilty, or you might be bound over for trial. And they have to decide whether or not you present a danger to the community. And if you do, they'll set a bail, basically assuring that you come back to your future hearings. And the Eighth Amendment is triggered there because you can't have excessive bail. The trial, we'll be learning all about that next week, about the rights that happen during a trial. And then sentencing, if you are found guilty, then you are sentenced, and the Eighth Amendment applies to the sentencing. The sentencing cannot be cruel or unusual. And then finally, in the appeals process, aspects of the Fifth Amendment are triggered because the prosecution, if you're acquitted, you can't be tried again. Prosecution can't give it another try, right? Because the Fifth Amendment prohibits double jeopardy. We'll be learning about that next week. And so anyways, that's just, sort of an overview of those steps and the way the amendments that you're going to be learning about in this chapter and the next one intersect with those steps. So the first step in the process is once a crime has been reported or witnessed by law enforcement, then an investigation starts, okay? And so the question there is, why does the government conduct searches? Well, the state has an obligation to stop and to hold accountable those who commit crimes, right? I tell my students all the time in my criminal justice class, I tell them that, look, and I think I've told you guys this too in the civil liberties class, it's sort of like, we have all of these liberties as individuals living in a democracy: the right to freely speak, the right to worship, the right to, bear arms, the right to have privacy in our home, the right to, have freedom of the press. But I tell my students all the time, the right to assemble, right, and protest the government. But I tell my students all the time that those rights don't really mean very much. The right to freely speak and worship and assemble. If you're really worried that if you take step outside of your home, or even when you're in your home, the right to privacy, if you don't feel safe, right? If you walk out, in the alley to get in your car, right, and drive out of your, your garage, and then there's somebody there waiting to shoot you, right? Or you're walking down the street, or you're going to a protest, or going down house of worship, and it's dangerous out there, right? Well, then those rights don't really mean anything, because you really can't exercise those rights because crime will be rampant. So the state has an obligation to stop and punish those who commit crimes, okay? Because if they fail to do that, then we don't really have a social contract, right? We would be living in the state of nature. And investigations are a crucial part of criminal justice, right? If you want law enforcement to have enough power, you want the government to have enough power to investigate potential criminal activities, figure out whether or not somebody's involved in a criminal activity, and then continue that investigation and arrest them and then try them to determine whether or not they have indeed committed this crime and should be held accountable. So searching, investigating, that's a crucial part of the criminal justice system. But as I tell my students in criminal justice, that it's really easy to be crime control, fight crime in an authoritarian, if you live in an authoritarian regime. In an authoritarian regime, there's no limits on the government power. They can do whatever they want. There might be a constitution, there might be laws, but the government doesn't follow it. It's like a sham, right? And it's easy for an authoritarian government to investigate crime. because they can search whatever they want. They can, there's no rules regarding collection of evidence. There's no rules regarding questioning somebody. There's no rules of trial, etc. They can do whatever they want. Makes it easy to fight crime. But I mean, that makes a mockery out of the whole notion of justice. Okay. In a democracy, it's harder to fight crime, and it should be harder to fight crime, right? Because in a democracy, it's essential that the investigation, it corresponds with the due process of law. Of course, we want the government to be able to apprehend wrongdoers and hold them accountable for violating our laws and our social contract. But they must do it in a way that corresponds with the due process of law. And that basically means that due process of law means that the government operates within the law. They're not above the law. They follow the law. And that they need to provide fair process for the people who are accused of crimes or being investigated of crimes, and that respects the rights of the citizens that are outlined in the Bill of Rights. And so, yes, that it's more difficult to fight crime in a democracy that follows due process and the rule of law and the rights of the people who live here. But it, at least theoretically, upholds justice, right? Because then when somebody is arrested and tried and found guilty, that we have confidence that the person who actually did the crime is being held responsible for it. I'm fully aware that we fall short of that all of the time, right? But the Supreme Court is sort of responsible for bringing us closer to realizing due process and to making fully vibrant what the rights in the Bill of Rights mean for citizens living in a democracy. So the Fourth Amendment this is where we're going to start, places constraints on the government while investigating crimes. Okay. And so that the investigation of the crime is probably the most crucial part of the criminal justice process, because it's there that we make sure that if the rules are followed, that somebody who didn't commit a crime isn't going to be unjustly or unfairly investigated or arrested. But also that when we follow the rules and then we do collect evidence according to the rule of law, we have more confidence that because the rules were followed and everybody's given that same fair process, we have more confidence that the person who's being arrested and searched and tried, that we have more confidence that they actually engaged in wrongdoing. Okay, so there are two clauses in the Fourth Amendment, as there are clauses in many of the amendments we've learned about this semester. And so I'm going to put both of the clauses up here, and this is the full language of the Fourth Amendment. It's just that we talk about the Fourth Amendment as having these two clauses. So the Fourth Amendment reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizure shall not be violated." Okay? So one part of the Fourth Amendment is known as the reasonable clause. It's telling us that that people's houses, their person, their bodies, the things that are in their houses, their papers, their effects, their personal effects, that the government can't intrude on those in an unreasonable way. And so we're going to spend some time talking about what constitutes reasonable search. The other part of the Fourth Amendment is the Warrants Clause. And so it says that the right of the people, that you won't be searched and seized in an unreasonable manner. Okay. The Warrants Clause says, and no warrant shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons and things to be seized. And that's known as the Warrants Clause. Your textbook talks about how the colonists were subject to these sort of general warrants, that basically a government would get a warrant to search, but they could search for whatever they wanted, for whoever they wanted, any place they wanted. There were no limits on that search. And so the Warrants Clause is saying that if you do get a warrant to search, and you're going to find out in the textbook and in lecture, you don't always need a warrant to search. But if you do get a warrant to search, it must be based on probable cause, and we'll talk about what that is in future lecture. That it is supported by oath or affirmation, and that is that has been interpreted as that the law enforcement need to make an oath on to confirm through an affidavit the probable cause that they have, and then it needs to be affirmed by a judge. Okay, and so you need a magistrate to produce a warrant so that they basically say, yep, the oath you made about the probable cause we have via an affidavit and the evidence that you're showing the court supports the claim of probable cause. And then the warrant also has to be particular. It has to describe what's the place that's going to be searched and the person and things that will be seized. So you don't have these general warrants that they talk about in your textbook as being an affront to liberty and justice, right? Where the government can just do whatever they want. So you've got the reasonable clause and the warrants clause. Okay, so as you know from the course of this semester, we know that the Bill of Rights applies to the actions of the government. Okay, so when we were talking about the First Amendment's freedom of speech clause doesn't apply to private corporations like Twitter or Facebook, right? They want to shut down your speech, they can shut down your speech. If they want to deplatform you like they did Trump, they can deplatform you, right? The same is true for the Fourth Amendment. So in the Fourth Amendment, the Fourth Amendment is doesn't talk about any the word search as used in the Fourth Amendment is not anyone looking for something. Okay, it's a very specific kind of search. In the context of the Fourth Amendment, the search has a very distinct meaning. It's defined as a police search. Okay, and so that the Fourth Amendment is saying that the people are secure from intrusions into their persons, houses, papers, and effects from the government. Okay, so it's a government agent intruding into your person's house, papers, and effects, a police search. So keep in mind the Fourth Amendment doesn't apply to, this is the example I used in my criminal justice class. If you go to the mall and it's a private mall and there's a private mall security agent and they're following you around and you have a backpack and they say, hey, we think you stole something, I want to search your backpack. You can't say, no, you can't do that. The Fourth Amendment, this is an unreasonable search. Now, the Fourth Amendment doesn't apply to that instance. Now, you might be able to sue that police security officer at the private mall for invasion of privacy, but the Fourth Amendment only applies to the actions of government agents, a police search. So the Fourth Amendment is placing a restraint on government actions, not on the actions of private individuals. But probably the bigger question that the court has wrestled with is what is actually a search? Okay, so as it says there, the question that the court has wrestled with is whether a search must be an actual intrusion into a physical space, where the government actually physically trespasses on your body or physically trespasses on your property or into your physical effects and papers, right? So the question is a search that triggers the Fourth Amendment, is it an actual physical trespass, or is a search something else, right? Is a search an intrusion into a place where one reasonably expresses privacy, or is it both? Okay, and so for the Fourth Amendment to actually be triggered, because it says the word search, is a search only a physical intrusion into your physicality, your house, your body, your actual effects, or is it when the government basically intrudes upon your reasonable expectation of privacy, right? That there's nothing physical that's being intruded upon, but what's being intruded upon is your private realm, your private space, wherever that takes place, okay? Whether it's in your house or elsewhere, okay? And so we're going to answer that question. We're going to start to answer that question about how the court has answered that question in Lecture 2, when we look at the shift in the way that the court has defined what constitutes a search. All right, thanks for your time, and I'll see you in Lecture 2.